of the appellant. Yes, sir.
Gary Smith at the Memphis Bar, representing Kerry Davis in the case of the death of his wife, Sylvia Davis. I would like to reserve 3 minutes for rebuttal. This is a wrongful death health care liability case which has been here before. We are back after a defense verdict in the case with several issues, each of which we believe commands reversal and remand. But the first issue I want to talk about was here before, and we are back on the same issue with the same complaint for which this court reversed the trial court before. Initially, the trial court granted summary judgment on the defense's contention that the plaintiff's expert, Dr. Garrettson, failed to establish during discovery sufficiently the issue of causation. They complained that his errata sheet and his affidavit filed in accordance with the opposition to their motion for summary judgment destroyed the credibility of that witness. The trial court agreed, granted summary judgment. This court reversed, and the reasons for this court's reversal are absolutely germane to the consideration of the issue here today, because this court made 3 findings in reversing the trial court before. 3 important findings. Number 1, whereas the defense contended that Dr. Garrettson's affidavit was inappropriately filed in response to their motion for summary judgment, this court said no, it was properly filed. That's a quote. And I'll come back to it. Secondly, this court found that the affidavit of Dr. Garrettson filed in opposition to the summary judgment and his deposition testimony do not materially differ. Third, this court found that the defendant's interpretation of some of Dr. Garrettson's testimony that they challenged was taken out of context, and that context was explained in the opinion authored by Judge Armstrong. Once the case got back to the trial court, the defense moved to take a second deposition of Dr. Garrettson because they still challenged that errata sheet, its credibility, the affidavit, its credibility, the affidavit, and the propriety of filing same, even though this court had ruled against them on those very issues. We objected, saying that this court's opinion constituted the law of the case. The trial court overruled our objection and allowed the second deposition, which inquired again into the impropriety of the filing of the affidavit, the credibility of Dr. Garrettson in the errata sheet and the affidavit, the very issues that this court had already ruled on. And when we got to trial, the defense pursued those very issues over and over and over and over again, ad nauseum, in opening, in cross-examination of Dr. Garrettson, and in closing argument. Some of which we have quoted in the brief. There was a lot more. It was that constant drumbeat on the same 2 issues, the credibility of Dr. Garrettson because of the impropriety of that affidavit, the impropriety of the errata sheet, the destruction of his credibility accordingly because he, quote, changed his testimony, contrary to the findings of this court. Once this court ruled that that affidavit was appropriately filed at trial, the defense argued that Dr. Garrettson and myself were guilty of some nefarious, inappropriate conduct in the filing of that affidavit. This court did not agree. It became the central theme of their attack on Dr. Garrettson, our only expert in the case. It never stopped. It became the rule, the invocation of the rule of the law of the case when this court wrote that opinion with those 3 findings, all of which they went right back after, just as they did on summary judgment when we got to the trial level. Their contention which the trial judge agreed with, was that your ruling here was of no moment to the trial because it was just considering the summary judgment stage, and it did not apply to a trial. That is not the law. The law was established in 1998 by the Tennessee Supreme Court in the Memphis Publishing case. And that court said, an appeals court decision on an issue of law is binding in later trials or appeals of the same case if the facts on the second trial or appeal are substantially the same as the facts in the first trial or appeal. They're not similar in this case. They are identical, exactly the same. Moreover, this very court, 3 months ago, in May, revisited the issue of the rule of the law of the case. That was in the Cordova opinion versus Nashville Ready Mix. This court said, the law of the case doctrine under the appellate court's ruling becomes the law of the case, binding on the parties and the trial court on remand. That concept, that rule, that law was absolutely 100% unequivocally violated in this case, and it commands reversal. Again, the record is replete with the attacks on the same issues that you've already ruled against them on. We moved in limine to exclude their ability to do that at trial. The judge overruled our motion in limine. So having overruled it, we next said, all right, if you're going to let them do it, then give instructions to the jury to the effect of what the Court of Appeals ruled. And one of them we attributed to the Court of Appeals. But alternatively, we gave her two more and quoted identically the language of Judge Armstrong's authored opinion of a unanimous opinion of this court on those issues about the affidavit, the context, and the errata sheet, and gave her the exact language from the ruling of this court, two instructions. The court declined to give them. We believe, without question, that that is reversible error, and the law of the case doctrine was violated and commands reversal. Now, there are some other issues.
Is that your major issue, that the court refused to charge the jury according to the opinion of this court? That's
correct. We gave her proposed instructions as limiting instructions or in final instructions that contained the precise language on these issues, verbatim, and the court refused to give them. And the court also gave, we believed, erroneous jury instructions in two respects. One, the defense requested, and the judge gave the alternative methods instruction. This was not an alternative methods case. Just a brief snippet of the facts. This was a case where Dr. Ellis comes in to the emergency room for a patient who's been there for 30 hours. Treatment has been unsuccessful. All has been done in supportive care that can be done. He transfers her to ICU with the prediction that she will get worse, with the prediction that she will require intubation, but with no plan to do it, and he leaves. And he leaves under this circumstance. He said, you know, I would intubate on a patient like this in respiratory distress if that patient for 30 minutes to an hour has a systolic blood pressure below 90. When he got there, she was below 90. He testified he does not know how long she had been under 90. He does not know whether she did or did not meet his criteria for intubation at that time. And even without that knowledge, he transfers her, he signs off, puts her on another doctor who's not there, anticipating that she will require intubation in order to avoid a respiratory crash. Well, the respiratory crash happened, and it was too late. He did not anticipate what was agreed to by everybody. If she progresses, as he says she will, to the need for intubation, it might occur where you've got that 30-minute or so window to watch the blood pressure, or it may just be a crash. And that's an emergency, which creates a difficult intubation. It was an emergency crash. There was nobody there to take care of it. By the time they get emergency up there, they can't intubate her because she's frothing at the mouth, and by the time they get anesthesia there, it's 30 minutes later. They get her back for a while, but she crashes again and she dies. It's not an alternative method.
Was the testimony presented that this violated the standard of care?
Yes, absolutely. Our proof was that when you see, after 30 hours, supportive care with 100% oxygen, that's all I can give her, is not working, and you see that she's going to get worse and she's going to need intubation, in order to avoid her crashing on an emergency basis, you intubate then. Now, importantly,
What are you asking us then to do? Would that be asking us to rule as a matter of law that this would be a violation?
no. What I'm asking you to do right now is consider that it was error to charge alternative methods. This was not a case where a surgeon makes the decision, do I do an open procedure or do I do a laparoscope? Those are alternative methods. This was not a case of an...
Is that a question for the jury?
No, not when it's not an alternative method. That's giving the jury the option of utilizing an instruction of law that is inappropriate. Waiting for something to happen without providing treatment for a treatment that is necessary, that's not an alternative method. It's not like an anesthesiologist choosing the type of induction agent and the amount of that induction agent versus another induction agent and amount. Those are alternative methods. There was no alternative method here, so it was error to charge it. It was also error to charge the hindsight. She gave the hindsight instruction at the request of the defense, saying that it's to be judged, the doctor's conduct is to be judged at the time of the patient's injury. The time of the patient's injury was when she crashed after he left.
The alternative method instruction, was that also given at the request of the defense?
Yes,
Okay.
it was. And it also is inconsistent in this situation with Clanahan versus Cooley and the concept of foreseeability. In the final 30 seconds, let me simply, well, actually, I'm over. So I will rely on my brief for the other issues, which included their inappropriate addition of an expert opinion, which we objected to.
Thank you, sir. Mm-hmm. Yes, ma'am.
Good afternoon, Your Honors. Jennifer Harrison from the Memphis Bar. I represent Dr. Garrettson Ellis throughout this entire litigation in front of Your Honor, albeit virtually 5 years ago, and throughout the trial. We are here because there was a defense verdict in this case, and when asked to serve as 13th juror, the trial court accepted that verdict. I need to pick up a few pieces before launching to my argument. I am holding, Judge Armstrong, I am holding the opinion that was delivered in Kerry Davis #1 and filed November 5th, 2020. There is not a single mention in this opinion. And I went back and I listened to the oral argument. Neither one of us argued Dr. Gunnarson's errata sheet. Neither one of us. It was not argued. It was not part of this court's analysis, and it's nowhere in the court's opinion. So the errata sheet was not really discussed until I got to depose Dr. Gunnarsson the second time. So the part about the court's ruling about the errata sheet is just inaccurate. What this court did rule 5 years ago was two things. Number one, Dr. Gunnarsson's affidavit was properly submitted in response to Dr. Ellis's motion for summary judgment. And number two, Dr. Gunnarsson's first deposition testimony combined with his affidavit was sufficient to create genuine issues of material fact for the jury to consider. The court didn't make factual findings. The court reversed, remanded for further proceedings, if necessary, as consistent with this court's opinion, and that is exactly what Dr. Ellis and the trial court did throughout, ever since that opinion came out. There was no question of Dr. Garrettson at trial about changes in his affidavit. We asked him exactly what this court said and exactly what plaintiff said. You were simply clarifying, weren't you? And he said yes. That was it. That was the extent of his inquiry at trial. The errata sheet was different because we never got to argue the errata sheet here, and we discussed changes, for example, could to would. So, did we ask Dr. Garrettson at trial? Has he been deposed twice in this case, given an affidavit and errata sheet? We did, because credibility, which has been repeated a couple times before I stood here, is a jury function. And the court was absolutely right pursuant to Rules of Evidence 611, 613, to allow open cross of Dr. Garrettson on his various forms of testimony in this case. He was never challenged on the rulings of this case. Now, 13th juror. Trial court did not abuse its discretion when it approved the jury's verdict because the medical records, the testimony of Dr. Rice, the 2 medical ICU nurses, there's no mention in plaintiff's brief, and you didn't hear it before I stood up. There were 2 medical ICU nurses at night who took care of Miss Davis, who testified at trial via deposition testimony video. And Dr. Ellis' testimony support the verdict that Dr. Ellis was not at fault. That was it. There were 3 questions. Jury made it to number 1. Never made it to causation, never made it to damages. Second issue raised on appeal. When the trial court allowed cross-examination of Dr. Garrettson, because our rules of evidence allowed and because neither the trial court nor Dr. Ellis ever strayed from this court's 2020 Davis v. Ellis opinion. I think I've covered that. When it allowed Dr. Rice to testify regarding the differences between a medical ICU and the CV ICU, because number 1, that's just a fact. It's a fact. Like there's a trial court, there's a court of appeals, and there's Tennessee Supreme Court. That's just a fact. By the way, Dr. Garrettson, plaintiff's expert, Dr. Ellis, who was medical director of the medical ICU at Germantown Methodist, and Dr. Rice, all 3 agree. There are different ICUs. Dr. Garrettson works in the heart unit, and Dr. Rice and Dr. Ellis work in the medical unit. Those are just differences. But if it's an opinion, let me back up. There are 2 reasons about the differences between CV ICU. It was objected when Dr. Rice was asked about the differences between CV ICU and medical ICU. However, it was already before the jury. It was already before the jury because Dr. Garrettson testified about the differences the day before when he took the stand at trial. Also, Exhibit 7 at trial is Dr. Rice's CV, and I think it's on the first page maybe. It says, I am medical director of the medical ICU at Vanderbilt Hospital. So it was already before the jury. But even if somehow these differences are determined to be an opinion, Dr. Ellis's Rule 26 disclosure had the general statement that it's not an exhaustive list of the facts or opinions, and he'll refute whatever Dr. Garrettson said at trial, and he said it the day before. And it came through Dr. Ellis on the final day of trial. Number 4, when the trial court instructed the jury, because the instructions fairly defined the legal issues, they came straight from the Tennessee pattern jury instruction or Tennessee case law, and because testimony from plaintiff's own experts support all the issues. At our oral argument in 2020, inside the Court of Appeals opinion of 2020, 7 to 8 times in Dr. Garrettson's affidavit that this court considered 5 years ago, replete with the word alternative. Alternative methods. There were options. He testified at trial. Dr. Ellis had options. There were different things that he could have done. He could have done this, he could have done that. He had options. There were alternatives. He brought that word up by way of his 6-page affidavit. The jury instruction was absolutely appropriate. Number 5, when it allowed evidence of remarriage. This issue, first of all, the jury never made it to the issue of remarriage because they marked X at no fault, stopped right there, and return the verdict sheet per the judge's instruction. But I want to take that a little bit further, because in plaintiff's opening statement, there's this quote: "Consider the first year not married as part of damage feature of this case that you will be asked to consider if you find fault." That's in plaintiff's opening. So before the judge, before I said anything in opening, before the judge gave instruction, before the jury heard anything about it, plaintiff advised the jury that you will determine damages 1 year of marriage if you find that Dr. Ellis was at fault. Again, he was not. Also, on the issue of remarriage, this comes, when we tried this case, it was 25 years out from Jordan v. Baptist, Three Rivers. It should have been allowed because after the case they cites from 1972, where Magnavox v. Phelps, I think it's Phelps v. Magnavox, actually helps me. So let me just go there. First of all, there was no loss of consortium in 1972. Fast forward 27 years later, and we have Jordan v. Baptist, Three Rivers, and now you can have a loss of consortium case. So this is real simple. Remarriage in this case would not have been relevant if Mr. Davis were not seeking loss of consortium damages. But because he was, they are indeed relevant, and it should have been considered. It is human consortium, and he regained 1 year after the death of his wife, the unfortunate passing of Sylvia Davis. 1 year after that, he regained his consortium. But let me talk about the case that they cite, because this is exactly what it says. Phelps v. Magnavox from 53 years ago. The only reason that the fact of remarriage could be introduced would be to mitigate the widow's damages, and she has none in this case, because there was no such thing of spousal loss of consortium 53 years ago. Furthermore, just on this issue of remarriage, it's not prejudicial to liability. So if it shouldn't have been talked about, jury never made it there. It's only admissible to jury's assessment of damages, and again, there were none here. Final issue. Trial court did not abuse its discretion when it awarded half of the discretionary costs that were sought, because the rules of procedure allow it, and because there's no litigation misconduct that would have precluded an award. Let me go back to cross-examination of Dr. Garrettson. I mentioned 611B, 613A, and also I'll mention Rule of Procedure 3201 regarding how deposition can be used to contradict or impeach. On the issue of remarriage and on the issue of blowing up this Court of Appeals opinion in front of a jury, assuming they would have understood what summary judgment meant, there is not a single case cited that is relevant. There is no case cited for this unique request to blow up, whether it's dicta or whether it's an opinion, a ruling from this court. Not a single case cited for this unique request. Furthermore, assuming a jury would have understood it, this novel request would have risked unfair prejudice, confusion of the issues, and misleading the jury, especially since there was no analysis or mention of Dr. Gunnarson's errata sheet in this courtroom. Well, virtually. We were in the pandemic 5 years ago in 2020. The jury never heard that Dr. Gunnarson's affidavit was improper or different from his deposition. Again, neither Dr. Ellis nor the trial court ever strayed from the four corners of this court's opinion. What is really, what was attempted at the trial court was to use this court's opinion to try and bolster their expert, Dr. Garrettson. This court did not comment on the facts. This court did not comment on the credibility. And actually, our Tennessee Constitution says our judges cannot comment on the facts you give the law and the testimony. And that is exactly what happened in this case. And within an hour, there was a defense verdict. On redirect of Dr. Gunnarsson, because plaintiff's brief says we were not allowed, we were hamstrung, we were not allowed to discuss any of it, and Dr. Ellis' counsel had wide open cross of him. That's inaccurate. On redirect, Dr. Gunnarsson testified, his errata sheet and affidavit were to clarify. He explained the hypothetical speculation and how, because I took his deposition and I argued at the Court of Appeals, how I took it out of context. This all came out in front of the jury. There was misinterpreted Dr. Gunnarsson's testimony. That came out. There was further discussion about speculation. That all came out. They were not precluded from doing anything other than saying the Court of Appeals said the affidavit and the deposition didn't materially differ. We never said it did. As a matter of fact, plaintiff could have asked, Dr. Gunnarsson, did your deposition materially differ from your affidavit? He just didn't. Law of the case doctrine. If it is a factual finding or if it is dicta, it doesn't apply. Now, that may not really matter because we never ran afoul of this court's ruling ever, or any part of it, ever. This court, 5 years ago, read Dr. Gunnarsson's read his affidavit in the light most favorable to appellant because we were at the summary judgment stage. That's what that was. A matter of law that this court decided, reversed, sent it back to be tried before a jury, and that's exactly what happened, who determined the factual findings and credibility. Alternate method. It is contained in the original Davis v. Ellis Court of Opinion 3 times. And because it cites Dr. Gunnarsson's deposition. It's an alternative to intubation, quotes. Dr. Gunnarsson explained the intensivist had options. There's more than one way of addressing this. On direct, Dr. Gunnarsson said there are alternatives. There are options. You can intubate, but it's not necessary at about 4 p.m. You can do positive pressure ventilation. That's an appropriate consideration. Or you can make a plan to intubate later, which is exactly what Dr. Ellis did, documented, dictated, and handwritten in his record. And as medical director of the ICU, he escorted the patient to the ICU. His shift ended, and 10 other professionals in ICU provided care and treatment for Miss Sylvia Davis. If the tube had been placed in her throat at about 11:10 p.m., some 5 hours after Dr. Ellis's shift ended, there would be no Davis versus Dr. Ellis. She arrested because they couldn't get the tube in. That had nothing to do with Dr. Ellis at 4 o'clock or 6 o'clock. At any rate, Dr. Ellis testified Dr. Gunnarsson on cross. He said there are a couple of ways of doing this. On redirect, he said there are a couple of ways of handling this. There are many ways to do it. Dr. Ellis said, hey, Dr. Gunnarsson's alternative treatment plan was actually carried out after I left. So the alternative method was absolutely appropriate. Hindsight was appropriate because TCA 2926-115A1 says you judge at the time the alleged injury or wrongful act occurred. Doe v. Linder supports that, and Dr. Gunnarsson's direct, their expert, says when at the bedside at 4 p.m. And redirect, he says, I'm trying to put myself in Dr. Ellis's shoes. This is, trying to go through thinking at the time, approximately 4 p.m. And then again, in this court's opinion, it cites Dr. Gunnarsson's deposition that at the time when Dr. Ellis was at the bedside.
Thank you very much.
Thank you.
Your time has expired. You'll redirect, sir.
The contention that you just heard, that they never violated the ruling of this court, is absolutely 100% dead wrong. They did it over and over and over again. The idea is suggested to you by Ms. Harrison that they never challenged his affidavit or drew it into question in the trial court. It is replete throughout the record, opening, cross-examination, and closing. She argued in closing. He is the only witness who came in this courtroom. He gave a deposition. He did an errata sheet. He did an affidavit. He did another deposition. He is the only witness who came in this courtroom and changed his story again and again. He's the only one who lost his credibility because he changed his story again and again. This court has ruled on that. And if the record is reviewed, you will find that I am correct, she is wrong. They challenged him contrary to this court's ruling over and over again. In fact, it was their theory before the trial when arguing against our motion in limine that they were not constrained by this court's ruling from going after him, even on the affidavit, because that only counted as to summary judgment, not as to the trial. That is contrary to Memphis Publishing. It is contrary to Cordova. On the alternative method, by the way, she talks about how many times Dr. Gunnarsson talked about that. He did it. This is, again, where this court found they took him out of context. He was talking about the alternative of at least temporarily trying positive pressure ventilation, which would buy you some time, but it was his opinion that it would not work. It was also the opinion of Dr. Ellis it would not work. It was also the opinion of their expert, Dr. Rice, it would not work. That conjecture was talking about an alternative method that wasn't even tried and would not have worked if it had been tried. It was not an alternative method in the context of what we're talking about for those reasons. Now, she tries to defend the new opinion given Dr. Rice, which was on an innocuous point that they were trying to make, that there's a difference between what you do in making life-saving decisions on intubation in an ICU on one floor versus on another. But it was not an opinion that they disclosed. It was an opinion that they advocated. They tried to impeach Dr. Gunnarsson because he was not a regular ICU doctor. He was a cardiac ICU doctor, never mind that he's a critical care doctor who's trained in intubation and actually teaches how to do it and when to do it and under what circumstances to do it. But they wanted to use Dr. Rice to try to counter on that point, and they did not disclose. And the reasons that they tried to justify that are set forth in my brief, and my time is up. Thank you.
Thank you very much. I want to thank the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and ruling within a reasonable period of time. Again, thank you both, and you both may be excused. Madam Clerk, will you please adjourn court?